Many people are considering mediation as an alternative to litigation of their divorce proceedings. However, there's many important factors you should consider before deciding whether mediation is right for you. One important factor is, what is your extent of knowledge of the marital estate? Are you aware of all assets in the marital estate and debts, including assets and debts titled to your spouse? Do you have access to those assets and debts? Or alternatively, does one spouse within the family handle all the finances with little to no input from the other spouse? Or does one spouse control all the assets without providing information to the other spouse? Understand that the mediation process is voluntary and is frequently done on representations by the parties only, or in certain circumstances based solely on a single document provided for particular assets. Unfortunately, many parties suggest mediation as a way to try to control the process, or even to try to limit the amount of disclosure that's occurring. Another important factor to consider is your extent of knowledge of your claims under the divorce code. It is very important that you, at a minimum, consult with an attorney prior to going to mediation, so you have a full understanding of the claims that you are about to negotiate and compromise and even waive. Additionally, you should consider whether to retain an attorney to work with you through the mediation process. Mediators act as third-party neutrals. They do not represent you or advocate for your individual interests. Therefore, having an attorney that you can work with throughout the mediation process to understand various issues and matters can be very helpful. And certainly, if any agreement comes out of mediation, you should definitely have an attorney review that agreement prior to executing it, at which point it would become a binding contract.